Hi, welcome to Out of the Rough. I'm Fred Arnold, and in this show, we're going to highlight opportunities and solutions to help get you out of the rough and into success, both financially and personally. In these tough economic times, I want to bring to you practical solutions to many of today's challenges. Today, we have Dan Mortensen. And Dan, what you do every day is absolutely critical. The only problem is people don't find out about it until, unfortunately, the heirs have passed, because we're going to talk about trust, probate, kind of dealing with tax issues. Welcome to the show.
Thanks, Fred. Delighted to be here.
Now, you have quite a resume. Berkeley School of Business, Hastings Law, NYU. You also are certified?
Board certified in tax law. I'm the only one in Santa Clarita. There's about 400 of us statewide.
Okay, so really a specialist in tax law. And what else does your law firm, Mortensen Law? In fact, you're building a beautiful building on Lyons Avenue. Thanks for reinvesting in our economy. What do you specialize in at Mortensen Law?
Our practice areas are essentially a three-legged stool. We do tax controversy work. That is, we represent the taxpayer in litigation with the IRS, whether it's IRS appeals or federal tax court petitions. We also do pre-death planning, setting things up ahead of time, spending a little money now to save a lot of money later.
Doing it right?
Setting things up ahead of time, wills, trusts, powers of attorney, property transfers, in order to prevent significant delay and expense after someone passes away. And then we do post-death administration, and that is really taking someone, whoever's named, the successor trustee or the executor, taking them by the hand and walking them through the process of making final distribution of the estate, filing the final tax returns, paying the final bills, and making ultimate distribution of the remaining assets to those legally entitled to.
So let's break that down. There's 5 ways you were mentioning to me to liquidate, if you will, or distribute assets of someone's estate.
That is exactly right, Fred. There's everything you own will pass in one of 5 ways upon your death to whoever is legally entitled to receive it. So the first way assets pass is by operation of law automatically. The best example of that, Fred, would be if you and I owned a property as joint tenants and I got hit by a truck. The instant of my death, my interest in that property goes poof, disappears, and I no longer have any interest in that property whatsoever. It doesn't matter what my will says. It doesn't matter what my trust says. If we own it as joint tenants, it's yours,
and
100%.
We see that a lot with husband and wife as joint tenants. So yes, and it's much simpler to be able to distribute that asset or figure out where those assets lie.
So at the first spouse's death, that is a quick, simple solution. It is also the way property that's held as community property with right of survivorship passes by operation of law instantly the moment of your death. So that's the first way assets pass. The second way is assets that pass by contract. And contract assets are easy to identify because they all have one thing in common: a beneficiary designation.
So your checking or savings account.
You can put a beneficiary designation on financial accounts. Other contract assets would be like 401ks, 403bs for teachers, 457 plans for fire and police, IRAs, tax-deferred annuities, and life insurance policies. Those are all a contract between you and whoever's holding the asset that, upon receiving proof of your death, they are contractually bound to pay either the balance of the account or the death benefit under the policy to your designated beneficiary.
So that's by contract.
So that is a contractual arrangement for the transfer of assets upon the holder of those assets receiving proof of your death.
Now, another one I want to touch upon just briefly is probate. And probate can be painful.
Probate is misunderstood. A lot of people have heard the word, but I don't know that most people broadly understand when probate is required, and it's actually quite simple. When you die with assets titled in your name alone, no one can sign for those assets.
Yeah, you're no longer here.
You can't do it.
Correct.
And no one else is on title. We're stuck going through a court-supervised process, and that process is designed to ensure that your final tax return is paid and filed and paid, ensure that your creditors are paid, that if the estate is large enough that an estate tax return is filed and any estate taxes due are paid, that we get all the way down to the end of the probate. We petition for final distribution only after the court is certain that everybody else has been paid. And at that point, then if you had a valid will, we petition the court to order final distribution of the assets to the beneficiaries named in your will. And if you did not have a valid will, we petition the court to order final distribution of the assets to your next of kin as defined by state law.
Now, so we talked about probate and the fact that there's also something called a small estate, right? And if your estate's small enough, you don't have to go through that probate process if you don't have a trust.
That's exactly right, Fred. For statutorily defined small estates, that is where you own no real estate at the time of your death, and the total value of your other assets is less than $100,000. There is an affidavit procedure that you can utilize to transfer those assets without probate. They don't want to clog the courts up with those small cases. No point in that. And there's also an affidavit procedure under the same general rules for transferring automobiles registered with the DMV without going through probate.
Without going through it. And then that leaves us with the only item we haven't talked about, which is a trust.
Yeah, the fourth way assets pass is using the medium of a trust. And a trust, mechanically, the way a trust works is you set up a separate legal entity, separate from yourself, much like forming a corporation. And you transfer title to the assets out of your individual name, where they would be a probate, and into the name of the trust. So the trust is on title as the owner. The trust survives you, and it names successor trustees. Now, the trustee, remember, is the person that has legal signing authority to act on behalf of the trust. So if the trust survives you, and it names a successor trustee who can sign on behalf of the trust, and the assets are titled in the name of the trust, they can sign the deed distributing the property without ever going to court, without ever going through this long, painful, very expensive process called probate. And so it allows you to avoid significant expense and significant delay, but you have to do it ahead of time.
Yes, and that is the key. Is I must say that when I'm doing the home loans, probably 5% of those that come in the door actually have a trust, and of course we ask them to call you and get a trust set up. So let's review quick the 5 ways, and then after the break, we're going to go deeper into a trust, because I think that's absolutely critical. There's the operation of law, probate, contract by contract. You have an agreement, trust, which we're going to touch upon in a minute, and small estates. So
small estates affidavit.
Yeah, perfect. We're going to jump to a quick break, but when we come back, we're going to talk with Dan Mortensen on ways that you can really save quite a bit of money and help out your heirs by building up a trust.